Everybody, good morning, good afternoon, good evening, wherever you are, whoever you're doing it with, whatever, etc., etc. We forgot the most important part of our trial day. We forgot the mens rea. Let's do it.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
All right, there we go. Whew, it just feels weird if I don't do that. So there we are. That's the mens rea part of the day out of the way. We're starting the trial again after a long weekend. The big question today is there going to be a mistrial or not? Currently, nothing's going on in the courtroom. People are wandering around talking on their cell phones. We're watching it. We'll follow the court and we'll go live as soon as they get there. But in the meantime, first things first, we got to do the cocktail of the day. We crowdsourced this one. The first one that popped up that I had wanted to do or liked was the margarita. So that's what I don't know how I'm going to do this in a minute. But today's cocktail is going to be a margarita, a classic margarita. Now, gosh, let's see. I've got to try to organize this so that I can do this in a minute so I can clip it into a short. All right, let's do this. I'm ready. Go. Hey, today's cocktail is the classic margarita. First, you want to start off with some lime zest and a little bit of lemon zest in there too to make it pop. Drop a little pinch of salt in. Then you want to add 2 ounces of fresh squeezed lime juice. Fresh squeezed lime juice. Pour that right in. Then go with 2 ounces of triple sec. You want to get some triple sec or Cointreau or whatever it is you prefer. Drop that in there. 2 ounces of that. That'll top it off quite nicely. Drop that in your mixing glass. Then you want some good tequila. And surprisingly, the Kirkland Tequila Añejo is really, really good. It's a great cocktail tequila, great for even drinking straight. It's aged, so it's delish. Drop that in, 2 ounces of that. And then you know what? Just put another ounce in because you should always have a little bit more tequila than you have triple sec. So once you drop that in, then comes the magic. Throw in your ice. Stick in your mixing glass. Give it a good shake. Shake up that tequila. You want to get everything all mixed up. You want to get that zest flowing so it gets nice and mixed. Once you're done with that, boom, pop your glass off. I said, boom, pop your glass off. Break out your strainer and strain it straight into your margarita glass. Once you've topped that off, throw in a couple of lime wedges, boom, boom, and you are done with a classic margarita. None of that frozen stuff around here. Oh, damn, that's good. All right. Woo! It's going to be good. We got the tequila going. And Speaking of tequila, I don't know why I said that, but our guest host for the day is Chandler Remington. What's up, Chandler? Oh no, you're muted. You just blew your intro.
Good morning, good evening, hello, how are you? That looks like a really good margarita, and I'm jealous that it's 6 a.m. here because I really want one. That sounds really great.
I know, American Dreamy said no salt rim. You know what? Quite frankly, I just didn't have time. There should be a nice salt rim on it, but yeah. Sorry about that. I just didn't have time to lay out the salt bowl, get the salt in there, and into it. So
it's still a margarita.
It is. We might just have to remake one tomorrow, assuming there's a trial. So there we go.
I think it's a beautiful margarita, especially with a lime zest. I've never really done that before.
Oh, yeah, that just makes it pop even more. Why Jeff skipped arm day, started running out of breath, shaking a drink? No, I don't think that happened.
Yeah, I missed that part.
I missed that part too. I missed that part. I've just been holding my breath the whole time. All right, so just so people see what's going on here, this is what we're currently looking at. Waiting for court to start. There's nothing from the people at law and crime saying what time the trial is going to start or what's happening. So we're just going to keep monitoring it, and we'll let you know as soon as something happens.
Sounds good to me.
So there we go. Where are we? What are we doing? How are you doing, Chandler? You survived Effort Friday.
I somehow survived, yes. I'm doing good. I'm back on track for the week. I've been focusing on work and getting my LSAT stuff back in order, so all is well in my world.
All right. That's good. Had a good weekend, everything? Everything's great? It's great. New week's off to a great start. Had a good holiday yesterday?
Oh, yes. Yes, definitely. It was a lovely holiday.
Well, we didn't get one here in Korea, obviously.
Very sad.
So, yeah, so we're doing good here. We've got the trial coming in. I mean, not coming in. It's just, starting today after a long weekend. Sitting there waiting for something to happen. I'm trying to think how we can, just to let you know again, they're always not in a turtleneck this week. He's got a suit and tie today. He's not in a turtleneck. That's a changer up.
His outfit choices with his hair have been kind of interesting.
Yeah, well,
He looks good. I'd say that, he looks professional and put together.
Yeah, he's clean. He's good. So, hey, Flux, what's up? Wait, what holiday? Yesterday holiday.
Juneteenth.
Yeah, we got everybody in America had Juneteenth. That brand new holiday. Robin Noel, have you been following the missing sub that went to the Titanic? Of course I have.
And of course that happened. Didn't that happen right after Maritime Monday ended?
Yeah, the news broke like right after, so that was kind of fun. Mm-hmm. But I'm actually working on having a guest as someone who was actually in a submarine that was involved in an accident as a guest to talk a little bit about what it is.
Oh, that sounds good.
Yeah, it is. Great story he's got. But we're going to start the trial today. It could be the end of the trial real quick here. Could be a real quick end because there might be a mistrial. And people in chat are saying, well, why is there a possibility of a mistrial? The possibility of the jury's coming in. Somebody's coming in. What the hell? Maybe the judge is coming in. Yeah, it's the judge coming in.
On the record, please, the state of Florida versus Demons, president, defendant, his counsel, the assistant state attorney.
The trial could end right here.
My understanding is we're missing a couple of our jurors, so we're not ready to proceed yet, but my office did get a call from one of our jurors, Claudia Campuzano Mena. She evidently was in the emergency room on Friday. She thinks she had food poisoning is what I'm told. And
oh no.
She was discharged, everything seemed to be all right, and then she's back in the ER now as we speak.
Oh, we lost a juror.
She called to let us know. She said something about she getting checked out and examined now in the emergency room. She asked my secretary, can she come in the afternoon? So we don't know what her status is. And so I don't know how you want to handle it. So you talk about it amongst yourselves. Let me know all the jurors are not here. We're still missing 2. All right. So
2 in addition to her?
yes.
Okay.
Judge, can we approach the bench very briefly?
Sure.
All right. It's like, hi, welcome to court. Can we have a sidebar? I assume they're talking about. Anyways, we're sitting with the. Excuse me while I turn the volume down here.
Don't you just love when the audio does that?
Yeah, I'm glad he's finding something funny in all this. It's weird. I know he has some issues he's dealing with up there, but someone just needs to keep control. But anyway, so why is there a possibility of a mistrial? Because the prosecution, when they were cross-examining, or I'm sorry, when they're giving direct, it's so confusing when they declare someone a hostile witness because it's a direct examination, but they're treating it like cross-examination. So when the prosecutor was examining the mother of a female friend of his, the court specifically told her, do not read or do not show her or do not refer to this text message that she sent to someone saying that the defendant's management team had promised to pay her a lot of money And they didn't pay the money, so now she's going to cooperate with the police, and she's going to turn into snitch bitch and say the things that she should have said before. The court said, do not under any circumstances read that. The order was given. She went straight into it. She asked a few preliminary questions, and then she just said, did you say this in a text? And the defendant immediately moved for a mistrial. Because, I mean, you do not more blatantly disregard a judge than what she did. I mean, literally, don't read this, and she read it.
I mean, even after like direct orders from the judge and objections, from the defense, she kept going, which was so offensive. And it's just like, does this court have no authority to you? Do you have no respect for this judge's orders? I mean, it was absolutely ludicrous.
Ludicrous. Speaking of rappers, anyway, now turned actor. But what we've got is, again, the judge. I think he tipped his hand. Mm-hmm. Because he said, you talk to the defendant and see if he really wants this mistrial.
Yeah.
Because if he gets the mistrial, it can either be dismissed. The mistrial can either dismiss it with prejudice, which means it can never be brought up again in court, or it can just go back to square one and they can retry it. And if they retry it, then it could be another year or two before he goes to trial, and he's already been sitting in jail waiting for trial for about 4.5 years. So, if he declares a mistrial, he could be there for another 6, at least. But if it's dismissed with prejudice, then he just walks free, and the prosecution has to live with the fact that they may have let a double murderer off because of their shenanigans. Now, my personal feeling is that I think the judge tipped his hand. That if he wants the mistrial, I'll give it to him, but he just got to understand that may mean he's in jail for another 2 years before trial. So I think he's going to give it if they ask for it. Now, whether it's with prejudice or without prejudice, I think is iffy. I think he should dismiss the trial, declare a mistrial with prejudice, and never let the prosecution bring this case again, because you don't more blatantly disregard a judge's order than what he did. Than what she did, what the prosecutor did.
No, the prosecutor was absolutely out of line in every single way. The only good thing I can say about her is that her hair looked amazing from the back, unlike multiple other attorneys. That's the only thing I can say that she has going for her, and honestly,
Okay, well, hair arguments aside, back to the dismissal.
No, but she was what she did was completely against the court, and it was offensive and appalling.
Your mic is super loud again.
Sorry.
And I mean super loud. Like, drop it at least 40%, if you would be so kind. But yeah, so I think it needs to be dismissed with prejudice. At first, I said no. But I thought about it for a day over the weekend, and I thought it needs to be, because if they allow this to continue, the prosecution is going to continue to do this in other cases. They're going to continue to walk all over the judge's orders and think they have this freedom to pull shenanigans, and they have to be put in their place. And they have to deal with the conscience of knowing they may have let a double murderer off. So what are your thoughts, Chandler?
Well, I think that it should be dismissed with prejudice, and I hope that I sound a little less loud now.
You do. To me, anyway.
But I don't know if that's going to necessarily happen, and I don't know if it's going to be beneficial to this defendant. It all depends. I'm not sure if this judge will be inclined to lean that way, just because even though it was an egregious error, it does not seem necessarily intentional, even though I think it was intentional. I think it's hard to prove how intentional it was on the part of the prosecution.
It couldn't have been accidental. She couldn't accidentally have read the text message she was specifically told not to.
I mean, the grounds for dismissing with prejudice in Florida, I'm not really sure exactly how different it is from the grounds in California.
It's mostly, it almost has to be to the level of intentionally doing something to try to get a mistrial. But I mean, this is pretty egregious. And I think this You can't walk back from reading that text. And she didn't just read the text. She flat out accused, and I had to go back and re-listen to it. She flat out accused the defense team of paying off the witness. Well, this is kind of dumb here. So don't know what Law and Crime did, but we'll just knock them off here for a little bit. All right, we'll wait for something new to happen. So, yeah, I mean, how do you come back from that? You just read in front of the jury that she was promised, allegedly, the management company was supposed to pay her some money, perhaps in exchange for not cooperating with the police. And then, because the guy didn't pay her, now she's going to do what she should have done in the beginning and go Miss Snitch Bitch and tell them the things they didn't know.
Yeah, I don't know about that. I mean, it's definitely controversial.
Well, and then she accused the defense team of agreeing to pay off the witness.
Well, do you think that that's what was going on there? I mean, it's hard to tell.
No,
I don't think that's what was really going on.
Well,
I mean, that seems like an insidious accusation.
Paid off. Well, she made it. She flat out made it. You know, I was willing to give her the benefit of the doubt that she misspoke and meant to say the defendant, not the defense team, but she kind of did. And like I said, when the defense team, I mean, they jumped up and I mean, they were all over her for that. And she didn't. If she misspoke, that would have been the time when she jumps to her feet and goes, "Oh my God, I'm so sorry. I didn't mean to say that. Yeah, please give the jury some instruction that I misspoke. I didn't mean the defense. Of course, they would never do anything like that. I meant the defendant's management." She didn't do any of that. She just sat there and listened to it.
Well, I think that I don't know if it goes to sanctions, but there was a point where she started to testify in her questioning. Like, she asked a question, the witness answered, and she said that's false or that's incorrect. And so she was testifying at a certain point, and that I've never seen anything like that before.
Yeah, they made the objection that she was testifying, and so they sustained the objection and whatnot. But let's see what super chatters are saying, and we'll read some of the other stuff. Voodoo Berries, thank you so much for starting off these super chats. The Aussie $5 second motion for mistrial was asking if the defense promised to take care of her. Yeah, it was just kind of, and the reason they made two motions is so that the other lawyer could speak. It was one motion until the judge said, okay, now my colleague is going to talk about something else. And ordinarily, the judge said, well, is it your motion? Because if it's your motion, you speak. And then, oh no, it's his different motion. We got two motions to dismiss going here. So they just broke that up into two motions so that both of the lawyers could argue different points that are grounds for a mistrial.
Oh, they were pissed. I mean, I saw, like, when he got up, he was just raring to go. He was just waiting for her to stop saying what she was saying so that he could just lean into her. It was really intense.
Well, that was a big gamble, I think. And I talked about that last Friday. I mean, he had two options. One, the second she started to read that text, he could have objected. And then there would have been a sidebar. She would have got yelled at and trial would have moved on. He waited for her to read that entire thing. And basically, before she was able to put the period at the end of her sentence, he just said, objection, move for mistrial. He specifically waited for her to read the entire thing so that, and he knew where she was going with it, so that he could make the motion for a mistrial.
Now I have a question. The text that read into evidence, was that part of discovery already, or was that a new exhibit that they were trying to admit at that point in time?
It was apparently part of the discovery. Everybody knew it existed.
Okay.
But there was no foundation for it because she didn't remember the events that took. She allegedly didn't remember, and that's the thing. You can bring in things like that to show a prior inconsistent statement or to discredit someone. But she was saying this whole time, I didn't remember doing this. I don't remember saying that. I read these things. I don't remember, and not remembering something and saying something incorrectly are different. So that's why the defense kept saying you can't bring through the back door what you can't bring through the front door. And so she wanted just to say, oh, well, you don't remember? Here, let me read these things to refresh your mind. Oh, now you're, and then they declared her to be the hostile witness. So then they can start cross-examining and bringing up other evidence to impeach her testimony, which is what they tried to do. They tried to impeach her with that text. So that was in there.
It's my understanding that in order for somebody to be declared a hostile witness, they have to be answering questions sort of differently to their deposition. Am I incorrect about that?
Well, she was being hostile. You know, I mean, as you saw, and I mean, to the point where, I mean, it was after she was declared a hostile witness, but when they were saying, do you feel intimidated? Yes, you've been intimidating me this whole time, Ms. Prosecutor. She was brutal. She was a great witness. Kitchen Knife Rescue says, on a scale of 1 to sanctions, how bad was this mistake? It was mistrial mistake. It was possibly letting a double first degree murderer off forever level of a mistake.
So let me ask you another question. I just want to understand, because like I learn a lot when I watch trials. What is it that the prosecutor should have done that would have prevented a mistrial? And with that evidence, how could she have used that evidence without getting to that point? Should she have just moved on?
I don't know that she could have. Yeah, she should have just shut her mouth and moved on, and tried to ask some sort of question that from her or another witness that elicited the fact that she may have been paid by somebody.
Okay, because it seems like the evidence, well, if it was part of discovery, then she did have a right to ask about it. But the way that she was asking questions was what was incorrect and mistrial worthy.
Yeah, when the judge tells you don't do something, don't do it. I mean, she literally did exactly what he specifically said not to. Hey, Steve Gosney, just tuning in. Welcome, Steve. We're waiting for trial to start to see if we have a mistrial.
Hi, Yay. Steve.
And if they don't start soon, we'll go back and we'll watch that little bit if they don't start here in the next couple of minutes. Flux, bringing the $5 super chat. Mocha Dick Poon, XOXO, fully adjustable, blow for freedom. What does shit mean? Moo ha ha ha. She's a bad prosecutor. That was inappropriate, and the jury saw. Yes. Oh man, they did. I mean, literally, just you can't say anything more than when the judge says don't do this. Just don't do it. Well, let's go digging here, shall we? Tell us a little bit about who you are and where we can find you and what you're doing, Chandler, while I bring up some old law and crime video.
Okay, sure. Well, I'm Chandler Remington, and for those of you who don't know me, who have never met me before, I'm a California paralegal, and I stream occasionally. I have my own YouTube channel. You can find me at Remy, REMY_legal, or just look up my name, Chandler Remington. I have been covering bits and pieces of the Sarah Boone case with MLS Law. He's come on for all of my streams so far, and I also am planning on doing some stuff about the Zachariah Anderson trial, which we covered a couple of months ago. So yeah, you can go follow me on YouTube. You can follow me on Twitter at the same
time. Oh, hang on. They've gone back to court here.
Oh.
Introduction of evidence that could not be authenticated or through the leading questions of the government or the state. And the court denied the motion on the basis that there was not sufficient prejudice, essentially, to do so. What I wanted to do was to highlight, make a motion to strike the evidence that was elicited.
Okay, so they're not going to pursue the mistrial.
By a jury instruction. Essentially letting the jury know that evidence that's excluded and the evidentiary rules are in place to ensure that only properly authenticated and reliable evidence is put before them. And that's the reason for the rules. And when evidence is put before them that do not comport with the rules, it's because it has been determined under the rules to be either unreliable or insufficiently authenticated. The specific items which I was able to identify by recollection that were introduced and ought not have been in the manner that it was done include but are not limited to the following. And we move to strike it from the record any and all phone numbers that were contained in any document Holmes was Ms.
So
Holmes.
you're not talking about physical evidence that's been marked, something that's marked for evidence. You're talking about her testimony.
Both.
What was marked in that? Why don't we do this? Why don't you put it in writing, all right? File your motion, put it in writing, give State a chance to digest it, look at it, and I'll take a look at it, and we can get back, we can have a hearing on it. This just picking out certain, this, she said this or that, I don't know. Typically I rule on objections as they come. So, and I thought I ruled on all the objections. There's something that's in evidence that you're seeking me that's already been admitted that you want to strike and have excluded from evidence. I'm more than happy to talk to you about it and more than happy to listen to your arguments. But I think I need to have something to digest it. So why don't you put it in writing, give everybody a chance to look at it, and do some research on it and find out what the law is. I don't know what the law is on that.
On striking inadmissible evidence?
No, the law on having something that's in evidence removed from evidence. Something the jury already saw.
One
You
thing,
put it in writing.
I understand. One thing, Your Honor, we have another court reporter now. And I think if we're going to put it in writing, it should be complete enough, and we would need a transcript of Ms. Holmes's testimony so that we can be sure to identify all offending references.
I'm sure you can order that, and I'm
I
sure
think
that.
she's out for the week. Is she?
My understanding is that she had a calling from a higher authority.
Okay.
Fourth DCA is looking for transcripts.
I thought there was no higher.
Fourth DCA is looking for transcripts, and that's what my understanding she's working on. So you tell her what you need, and I'm sure she'll get it to you.
Okay.
All right, so we'll be in recess. I'm gonna make a phone call, and or have my Jay make a phone call, find out what the status of the juror is. All right?
Thank you, Judge.
We'll be in recess.
Okay. Huh. So it looks like they've decided not to. The defense has decided not to pursue the mistrial. So they're gonna go forward, and they're gonna try to get through this by way of a jury instruction. Now, we got to go back and catch up on a few super chats here. Marv White starts off here with the Greek boat disaster is getting no news coverage, but the missing Titanic sub is talked about every 10 minutes. This is why YouTube is my news. Well, that's because there's a billionaire on board the Titanic sub, and there wasn't a billionaire amongst these 700 people on the boat that capsized off Greece. Renee Matei says, please, for the love of Christ, stop hitting the desk mic. Is vibrating like a MF.
I'm so sorry. I'm working on upgrading my mic. My apologies.
Yeah. You do like when you put your elbow on the table, it kind of goes kind of like that because it vibrates the microphone. Unhung Hero says, so what is the remedy for the prosecution shenanigans? Well, it could have been a mistrial with prejudice. Like I said, it could have just gone away forever and ever, and it would have been done. But it seems like that's not the route they're going down. And Marv White, bring the $10 super chat. Greek boat tragedy is not getting any news coverage. Thank you for sharing it with us. I think it is BS. The news is covering the missing sub, but not that story. Let's see if he sees this super chat. I see all the super chats. You just wait. There wasn't time to read them all. Just chill. Chill, everybody. I saw that too as well from earlier on. Renee Matei saying, oh, thank you for ignoring my super chat. I don't ignore them. There was no time to read them. Calm down, people. I read all the super chats. No worries. If I read Flux's Mocha Dick Poon XOXO, etc., I'm going to read yours.
Sometimes you read them twice, especially when you're drunk or tipsy.
Yeah, exactly. And Peace Peony says, can the state change lead prosecutors mid-trial? Well, they have their prosecution team, so if one of them's gone, someone else can be there, and they can take over from each other. But you just have to be an attorney of record on that particular case. And Chandler's left us. She's disappeared. The Lorax sees all, people. Don't worry about the super chats. They will get read. I promise. As I said, they guarantee, your super chats guarantee things get read. Maybe not instantly, but we get there eventually. The Lonely Cockapoo says, so I turned 30 about an hour and a half ago. When is the back pain supposed to start? Well, any time now, any minute now, and cheers and happy birthday to you, the lonely Kakapo. Granted, it's a tequila cheers, but hey, it's a good margarita. Yum. Okay. Well, the jury already heard the bad stuff. Yes. That's why they're trying to put together a jury instruction that says the prosecutor did something really, really bad. Please ignore it. Let's see. How are we doing over here, by the way? Well, we're about halfway to Doggo Can. Interesting. Missing billionaire equals headline. Missing Greek is no. They weren't missing Greeks. They were missing Pakistanis, people from Libya, Egyptians, etc. that were on an overcrowded boat that capsized off the coast of Greece last week. They're expecting the death toll could get up to about 600 people. So it's a
Oh God. That's
regardless of why they were there and what people's immigration policies are, there's a potential loss of 600 human lives, including 100 women and children who were reportedly locked in the hold for safety purposes. Terrible tragedy. Loss of human life. We're for an indefinite period of time here, so I think we should go back and watch what the prosecutor did.
I agree.
And that's what I was trying to find when they see the best way to get the court to start again is to try to do something different, to try to go out of the box. Oh, what do you know? That little section seems to be amongst the most replayed. All right, I'm kind of fast forwarding here. Wish I could remember. Wish I had a timestamp for this, but I don't. So bear with me here. Chandler, do you have any stories to tell while I do this?
Any stories to tell?
Yeah.
Stories about mistrials, about
anything.
About anything.
Yeah. Do you have any stories to tell while I try to find this little part of the trial? While I scroll through 7 hours.
Not off the top of my head. It is a little bit early. I'll be more entertaining in about half an hour when the tea kicks in. I'm just reading Steve's messages.
Oh, what's Steve got to say? You can read the messages while I do this.
Well, Steve is saying, so the judge denied the mistrial motion? If so, now the defense is asking for some helpful sanctions. That would make more sense than abandoning the mistrial motion.
Well, we're not sure exactly what happened on that because the last thing we had Friday is the judge sort of seemed to tip his hand that he might be inclined to give the mistrial because his words were consult with your client and see if he really wants to proceed with this, knowing he could remain in jail for a significant amount of time before the next trial. So I don't know if he denied it or if they said after consultation with our client, we've decided not to pursue the motion. I don't know what they did because Court TV wasn't having any of it.
Everybody's asking Steve to come on. I always love when Steve comes on for the Florida cases because he has the expertise, certainly.
Well, let's see. All right. Dang it.
He provides a lot of insight. Gosney is a treasure.
Oh, if anybody has a timestamp when they first talked about the trial, when they first talked about the text messages and not being able to bring them, I think it was around the 5 hour and 30 minute mark somewhere, but I'm scrolling through and I'm not finding it.
Well, I watched it on your stream, so I can tell you how long it was into your stream, but watching yourself and your commentary again might not be the thing you're going for.
That's kind of weird. Crap, I can't find it. Dang it.
I believe in you, Jeff. You can do it.
No, I'm just killing. I'm killing the stream here. That's so. Playing the clip's not the problem. It's finding the clip. Like the first time that the prosecutor brought it up, and they were trying to get it introduced into evidence, and I just frankly can't find it because it was before the witness came because they knew where they were going to go with it. I wonder. Because I know it was right about the 50-minute mark on my stream. So, well, Corn Pope's good at finding things. So we'll let Corn Pope search desperately for it. And while we're doing that, okay, I'm sorry. I was looking at Law and Crimes chat, not my own. We did have another chat here. Kara says, crazy that in Florida, it only takes 8 to 4 for capital punishment. Right. At this point, it's only, if you're convicted and you're facing the death penalty, it only takes 8 of the 12 jurors to send you to your death.
Well, but then it takes the judge to approve that.
But it's the law, so there's really no reason he
Right.
wouldn't. I have a story on prosecutors blasting BS info in front of juries. I bet you have a lot of those stories, Steve. Yeah.
Oh, you're kidding. Really? Prosecutors behaving badly?
I know, and of course, you're always welcome here, Steve, if you ever have time. Gosh, again, there's no indication that the judge says he's going to find out what the jury was doing. So that's why I don't think. Okay, we're still waiting for the judge to rule on the motion for the Law and Crime says we're still waiting for the judge to rule on the motion for mistrial. The judge is talking with the bailiff about the sick juror who is in the hospital. So according to Law and Crime, they haven't actually ruled on it, but it sounds like they're not doing it. What's the Titanic sub-story? The Titanic sub-story is a group of people paid $250,000 apiece to go down in a deep sea submersible submarine and explore the Titanic wreckage. And their communication equipment went out shortly after they went under the water, and they're lost and nobody knows where they are. And they've got about 72 hours of oxygen. Did this prosecutor train under Gravely too? She's a brazen prosecutor. So we could drop a "don't get brazen with me" thing on her.
Problems in Wisconsin, problems
the Titanic
in Florida.
Kills again. Exactly. There's 3 sick jurors apparently, and one that's in the ER. Apparently said it was food poisoning. So,
was it from like a catered lunch? Because that sounds suspicious.
Well, I mean, the last catered lunch was 4 days ago, so probably not.
Wait, so there are 3 jurors that are out with food poisoning?
I just heard one. So I don't know where the 3 came
That's
from.
what I thought too. I don't know why I got a little confused there. Well, speaking of losing subs, everybody check and make sure that you're still subscribed to Legal Vices because YouTube does this thing where it unsubscribes people, and we're trying to get the Lorax to 50,000.
And so I'm 36,881 right now. I'm 19 away from 36,900. So that's kind of cool.
You're really close.
I am. We got 829 people here watching me desperately trying to find this clip. I'm going to have to go back on my stream because as I remember, I told you it was about the 54-minute mark on my stream. So if I can go back to my day 4 stream, which I can, because that's how I roll. All right, go back to my stream. About, I think it was right around the 54-minute mark, was it?
Yeah, it was.
It was.
That was where I clipped it.
So let's see what was going on at that time. It was leaning up against the sidebar there. Everybody's walking around. Okay, it was just before she took the stand. This lady did. So, all right. I'm going to go back in time. Make sure, okay, we've still got the court cam going.
Steve can come on for 10 minutes. Oh, I would love that.
All right, Steve, I will tweet you a link. That's it would take me 10 minutes to open my email. All right. Well, that just means I have to open Twitter. I can do instantly, which I just did. So,
all aboard the struggle bus.
Steve Gosney. Boom. Message. All right. I sent you the link. Steve Gosney. And you can entertain us for 10 minutes with your words of wisdom, wit, and wisdom from the courtroom. Okay. No tweets at work. All right. All right. Hang on, everybody. I have to.
Oh, I could have sent him the link. You sent it to him via email?
No, I sent it via Twitter. Now I have to send
okay.
it by email.
He's saying he got it. Okay.
Oh, wait a minute. Okay.
I'm
Then I'll
slow. I should
stop.
have volunteered so that you could do what you're doing.
Okay, so you got us. Okay, there we are. Hi, Steve. How are you doing?
Hey, how you doing?
Steve Gosney, everybody. Great. Things are awesome, aren't they?
I gotta make sure I'm struggling. Can you hear me?
We can hear you just fine.
Hey, yeah, I got a quick story if you want. I've got about 10 minutes. I'll take a smoking break here.
Okay.
Yeah, just getting stuff straight. How you doing, Chandler? Good to see you.
Oh,
and thank you, by the way. Chandler's my secret squirrel.
Hang on,
Did you get my email
judge is
last
back.
night?
Hang on, Ann.
Okay,
And
good.
she believes that she's dehydrated. And that's giving her fluids. She thinks, can't confirm it, that she'll get out sometime today, and she thinks that she'll be here by 1:30. But nothing's definite now, doesn't know. So I wanted you guys to talk it over and let me know what you think.
Yes, sir.
And we'll make a decision.
Yes, sir.
All right.
Thank you, Judge.
We're in recess.
All right. Back to you, Steve.
Yeah, just wanted to share. I've got a great story, and nobody's heard this one. This is a
it's a new one.
private story, or maybe I should say it's not a private story. It's in one of my appeals, but it's related to this, and we can talk about the specific case while you're looking up the prior. So I'll tell the story. You look up the time when they blasted the improper information. Okay, but see what happens is defense attorneys. There's something that should not be in evidence. All right. And now listen to this story, okay? You got to be careful. You got to think through it very carefully. So what happened was I had a client who had 2 cases. He goes to, and he's in jail on case number 1. He says, I didn't do it. He's in jail, and he fights that case and wins at a jury trial and is released from prison. I'll pull that one
Oh, my
down.
God. Steve, can I interrupt you just for a quick second?
Yeah, go ahead.
They're talking again. I don't know about what. Hang on.
One,
Can I go ask the witness really quick on scheduling? So
Sure.
if it's gonna fit.
1 second.
Thank you.
Yeah.
Hang on.
Yeah, your hearing is at 4, Your Honor, so that'll be fine.
So the state's good with that, defense is good with that, 1:30.
Yes, sir.
Thank you, sir.
All right? You just tell them we'll be back at 1:30. Okay. Thank you.
Thank you.
Okay, so
All right, we'll be in recess.
1:30.
now now we just got to find out. Does that mean they're going to be in recess until 1:30, or they're just going to bring the jury in at 1:30 and they're going to decide whether or not to have the mistrial or what to do before then?
Well, there's some
that'll be
people that are saying in the chat that he's already denied the mistrial motion, and now the defense is seeking some sanction short of mistrial. That would make a lot more sense to me.
Yeah, what I'm thinking is because he never announced a ruling, so I'm thinking that the defense decided they didn't want to go forward with it because that was the admonishment.
I'd be surprised at that. I don't know why they would not ask for mistrial, because you know, and this is my stat. I'm very aggressive in mistrials because I do appeals, and if you don't ask for mistrial, you do not get an appeal. You're basically not preserving it. So that's very important for them to ask. So it makes sense to me that the judge has already denied the mistrial, and now they're looking for let's say we're preserving that, but with that preservation, we're still going to ask for this additional sanction, even though you've denied the mistrial. And then they can ask for the mistrial for appellate purposes. That's the way it would normally go, and that's the way I would advise trial attorneys to do it.
He's already been in jail for 4.5 years, and they're just now going to trial.
Yeah, I got you, and I know that the defendants don't want to hear that. But see, if you get a mistrial granted, and it is intentional by the state, okay, then that can be prejudicial to a second charge, because jeopardy attaches. Double jeopardy is a thing, and jeopardy attaches when the jury is sworn. Okay, so the cases in which double jeopardy has attached to bar a second prosecution can come when the state is like, the case isn't going the way the state wanted, and they intentionally blurt stuff out that they know is inadmissible, and then the defense asks for a mistrial, so the state is forcing a mistrial so they can redo what they're doing. All right, that's tricky, sneaky prosecutor trick. And then in those cases, there are cases in which subsequent retrials have been barred by double jeopardy. A murder case is very high stakes, and so they don't want to do that. The judge doesn't want to do it, and the appellate courts don't want to do it, but it is there, and it is a strong judicial remedy. So I got a really good story. I'll tell the reason I want to talk on it. I've only got 10 minutes. I'm sorry. I really
we got nothing better to do right now. So story away.
This is right on point on this, and I'll give you an example and tell you why the appellate courts don't like this. All right, this is an appellate story from one of my cases, and I brought it up here on my little thing. All right, so here's the case. I got a guy. He's a sex offender. All right, and he's married to, or he's married. He's got a girlfriend, or he's married, and he's charged with a felony domestic violence. And he says, I didn't do that. All right. He lives in a mobile home, and he's put in jail on the like felony battery on his girlfriend. He says, I didn't do it. Well, he sits in jail for like 8 months or a year or whatever it is, waiting for trial. He eventually gets a trial, and I think he demanded speedy trial, got a trial, and got a not guilty. All right.
Okay.
So he gets out of jail, and he goes back home to his mobile home, and his mobile home has been robbed and burned to the ground. All his personal possessions in the world have been disintegrated into ash. His landlord says, well, you can move in this mobile home 3 doors down. So he moves 3 doors down. He tells his probation officer, I moved 3 doors down. He goes down to the driver's license, because you have to not only tell your probation officer, you also have to tell the driver's license office that you're a sex offender, that I've changed addresses. And they say, well, we need your birth certificate and your driver's license to change your driver's license. He says, well, it all got burned up in ashes. And he's from Michigan, so he has to mail off to Michigan to get his driver's license. Well, what's the vindictive state do? They charge him with failure of a sex offender to register, because he didn't go to the driver's license office and register and change his address. And he says, yes, but my whole thing got burned up in the fire, and I was not able to do this. And well, you should have gotten a letter from them saying, from the DMV saying that they weren't, whatever, blah, 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 blah. Anyway, so he's charged with failure of a sex offender to register, right? Get it? Yeah, this is what I deal with. So here's what happens. So in the trial, so there's a jury trial on the failure to register sex offender. The defense says, the state wants to bring up the fact that he has this prior thing that he was in jail in. So they want to make him look bad. Well, he's charged not for the time that he was in jail, but from the time he was released from jail and moved to the 3 doors down, right? So they're trying to get that window, but they want to talk about the time he's in jail. And the defense gets winds of this and says, no, they shouldn't be able to do that because it's not charged. Get it? Get the setup?
Yep.
All right. So in granting the defense's motion in limine, the trial court rules, all right, well, the only operative time that you could possibly inquire about is whether or not the defense opens the door of some registration between December 2609 and ballpark it, say, July 19th, 2010. Well, then you could inquire about that. But if they don't open the door, the only talk about registration is after he's released. And then you can only attack that on cross-examined by portion of the time he's released. All right. So the judge grants the motion in limine. Prosecutor, you cannot talk about the time that he was in jail. Fair enough? So everybody's doing this is pre-trial. All right. And so here again, the judge says, if you registered on July 16th, She can attack that, but she can't attack it by going back and say, you didn't register between December 26th and July 15th because you were in jail, weren't you? You see, she can't bring up the fact he was in jail on a charge he was found not guilty on, or for any matter, it wasn't charged. Got it?
Yep.
And so the assistant state attorney says, well, who would do that? Quote, that's what she says. Well, who would do that? Of course, she wouldn't. All right. So great. So continuing, the trial court says to the assistant state attorney, you can't make the argument for the period of time between December 26th, 2009 and July 15th, 2010, only upon his release. And then the assistant state attorney says, obviously. Right. Okay. So we got this settled, right? It's all clear pre-trial what the rules are.
Yep.
All right. Well, so who does she call as a witness in the state's case in chief? The landlord. So the landlord, he says, during the state's case in chief, and what time did the defendant cease to be a tenant in your complex?
Oh, dear.
May 2011. All right. So the defense objects and says, sidebar, Your Honor, says, remember, we got this limiting ruling, right? You can't talk about the time he's in jail. So that's okay. So the prosecutor goes back and she reinitiates her questioning. Okay, so from December 2009 to July of 2010, did he pay any monies for Unit 53? And he says, no. And you hadn't heard from him? No. Okay, why in fact did you not hear from him again from July of 2010 or in July 2010? Defense objects, moves for mistrial, right? Second time, moves for mistrial. Jury's removed, denies the motion for mistrial, comes back, but sustains the objection that comes back the second time, right? So here's her first question after the first mistrial motion. So, Mr. Landlord, did the defendant become a tenant again in 2010? Objection. Second motion for mistrial. Okay. Sustained. Disregard. And the judge says disregard any dates before July 2010. Okay. So then they come back. What's the next thing that the state attorney says after the second mistrial motion, third scolding, and all of this stuff? Okay, Mr. Landlord, on July 1st of 2010, was the defendant a tenant of your complex? Answer, no. Objection. Third mistrial motion. During the discussion for the third mistrial motion on the same issue within minutes, that the judge asks the prosecutor, Mrs. Prosecutor, why would you persist in eliciting any testimony regarding a date prior to July 20th? Why is that necessary? And then here's the assistant state attorney. Here, she doesn't say, oh, I made a mistake or anything. She says, quote, because it's relevant. Oh. Because he went to live there in July and it was destroyed. And because of his bad luck, because of all this, it's not his fault. Cry, cry, cry for the defendant because of his bad luck.
Wow.
Yeah, that's what the assistant state attorney says. Third mistrial motion also denied.
What? Okay.
I raised this in a merit point in a brief. PCA ignored.
I don't understand how these keep getting denied. It doesn't make any sense to me.
Well, because we wouldn't want anybody to get away with anything, would we? It's ridiculous. Cheat. Not only cheat. Not knowing, like, okay, there's a pre-trial order, there's 3 mistrial motions, keeps going right back to the very thing that's not supposed to talk about, and there's no consequences at all.
Well,
Florida.
I mean, that's a lot of what's happening. I don't know. Have you been listening to any of this in the background, Steve?
I tuned in because I wanted to see the little clip on this case, which because I always like to see prosecutors being nasty little prosecutors, and so for my own little grift. So that's why I tuned in, because I knew that you were going to cover this.
Well, they've been doing this from the beginning. And first of all, the prosecution is just doing a very, very bad time management job.
The opening statements, I would say, were very businesslike. And so I was expecting them to be very businesslike. So I'm disappointed they've gone off the rails on exclusive evidence.
the defense team is fantastic, except for the weird woman that sits immediately to the defendant's right, she's just kind of weird. But the actual speaking attorneys for the defense are fantastic people. The prosecutors, they brought a glass expert on who testified for an hour about types of glass, different kinds of glass, and basically came down and said, we found some green glass, we found some clear glass, and we found some tinted glass. We don't know where they came from or what vehicles they belong to, but we found some glass. They brought a ballistics guy on for 3 hours, three and a half hours, who testified about how guns work. This is the trigger. This is a hammer. This is a magazine, and just forever and ever and ever. Oh, and then he went on to different types of ammo for different types of guns, different sizes. And at the end said basically, now we can't tie any of this to any particular gun. So they wasted 3.5 hours there. Then they brought on a forensics expert who testified about glass and bullets and reiterated it. It's terrible time management. But then they get to this is one of their star witnesses, the mother of the girl who was a friend of the defendant. And before she even got on, the prosecution said she's having memory problems. She doesn't seem to remember the things that she said during the depositions and the statements she gave to police. And so what they wanted to do is they wanted to refresh her memory by bringing in and showing these allegedly prior inconsistent statements.
Who does the state wants to bring in? You
Yes,
can't
for their
own witness.
Well, they had her. They eventually had her declared a hostile witness.
But that's ridiculous.
That was the whole thing. They said, well, she can't remember these things. She remembered them during the last deposition we gave. So we want to bring in her statements to show her that they're this way. And the defense rightfully said, well, not remembering something and giving a different answer are very, very different.
Right.
And he's just been harping, if you can't get it through the front door, you can't get it through the back door either.
Right.
And so that's what they wanted to do. They wanted to bring in her statements from her depositions and statements to the police to show that she really can remember. And say, well, we just want to refresh her memory. And they said, well, you had 4.5 years to refresh her memory. Let's not do that on the stand by showing her these other statements. And then they wanted to show this. They wanted to enter into evidence this random text that said, somebody else, the defense management agency promised to take care of us and promised to give me money, but they didn't pay me. So now I'm going to do what I should have done all along, which is turn Ms. Snitch bitch and tell them what they didn't know. So they wanted to use that to say that she has been paid off by the defendants to maybe forget.
Yeah, so they're trying to bring in. See, here's the problem: they're trying to impeach their own witness. So the state has called a witness. The witness says they don't remember. So now they're trying to refresh the recollection. The witness is being uncooperative and saying, I don't recollect anything. This doesn't refresh. No, I'm denying that. So now they are trying to impeach them. But see, the problem is that is substantive evidence. That's not proper for the state to impeach their own witness.
So that was the point. They had her declared a hostile witness. And the judge still said, no, you can't bring this in because there's no proof that this was a truthful statement she made to her friend. There's no basis to say this was a truthful statement that she made to the police. There's the veracity of this has not been established. There's no foundation for it. So they said, okay, fine. It's just the instruction was, do not talk about this text. Don't even bring it up. You're not allowed to bring it up. Doesn't meet the test. And so then she started saying, when you gave your statement to the police, did you lie to the police? Do you make it a habit of lying to the police? Obviously, she's going to say no. So, well, that obviously establishes the veracity of her statements to the police because she said she wouldn't lie to the police. And then she just said, now, on this date, did you say this in a text message? And read the text message. And the defendant...
the judges need to be much tougher on prosecutors when they play because there's clearly they're cheating. They're disobeying the judge. They're disobeying the law. They're not upholding the law. To me, this should be because see, I've actually got some proposals for correcting prosecutorial misconduct. One of them is automatic bar referrals, because these things it's like there's no sanction for the prosecutors to cheat, and this is a big problem. Hey, I'm sorry, I got to run. Is there any questions you have on this specifically for Florida law or anything? I jumped on. Thank you for letting me jump on. I did want. That was a pretty good story, wasn't it?
Yeah.
I just have a really quick question. I'm trying to understand, if this evidence was in discovery, then wouldn't it have been admissible, and why is it problematic to ask about it?
Well, the problem is because the state is trying to impeach their own witness, all right, and they're trying to bring in substantive evidence for they're through the witness that they've called is not giving them what they want. All right. So you have a prior inconsistent statement that they're trying to bring in as impeachment for substantive evidence of guilt. All right. Which is improper. It's very in the weeds evidence stuff. But the fact is it doesn't really matter. And let's just say it doesn't matter at this point. What matters is that the judge ruled it inadmissible. So
you did. Okay. That was something that I had missed.
So the key here is not that. See, this
well,
is
if it was ruled inadmissible, then obviously, then it's problematic. I understand that.
I mean,
Right,
exchanging things in discovery or disclosure, whatever you want to call it.
And there's also,
it doesn't mean it's automatically admissible.
There's also a question about whether or not the probative value exceeds the prejudicial effect. Okay, so that's kind of the evidentiary standard. So in this case, they would say, what's the probative value of this state, right? They're trying to impeach their own witness, which is improper. The prejudicial effect is great because it's smearing the defense team, saying that basically the defense team is lying or influencing something with sort of this out of court statements that this other witness made that is not there, that they're denying on the stand. So it's really, it's perjured testimony one way or the other, right? So the state is just trying to bring it so that, okay, but it doesn't really matter. What matters is the judge said it can't come in. Now, what you've got is the prosecutors are basically overruling the judge by bringing it in anyway.
I see. Okay, thank you very much.
And that's the cheat.
I understand.
That's the cheat. And and so then the question, then there's a whole analysis that you have to go into as far as how harmful is it? Is it harmful? Is it mistrial worthy? So it's very difficult to get to that standard. And then is it intentional on the part of the state? It sounds to me, see, this is the problem. It is intentional. What these prosecutors did, they know there's no sanction. They want to get in. They don't agree with the judge. And so I'm going to get it in anyway. And they know there's not going to be a consequence. Now, a lot of times when I advise people on this, they get the mistrial, it gets denied. I always ask for an instruction that gives me some presumptions. I think that's always good. Like he's saying, tell the jury this. Tell the jury to ignore the elephant in the room. I don't think that's ever a good remedy. Yeah. So I would rather get, as a remedy, I propose that they ask for a special jury instruction, providing a presumption that of some sort. So, you are instructed that this is the presumption that the state now have, and that gives you some legal something that the judge is saying to the jury. You can also have the judge call the state out on the record in front of the jury, which is something that they should do, should be much more common. But see, judges don't like to do that because they're elected and they see prosecutors as potential election candidates against them. And so they don't like to scold them in public. But I think that's a very good remedy also. The law is this, the court ruled that this is not something you should consider, and they were cheating, and you need to know that they were cheating. That's pretty good stuff, because what the state's trying to do is they're trying to point to the defense saying they were cheating. So it needs to be, the judge needs to say, no, I've ruled and the state is cheating. And I think that's also kind of effective, or at least it's better than nothing.
That's very informative. The state's behavior is egregious.
And I know you've got to remember, the state did actually accuse the entire defense team of paying off the witness.
The state also testified. There was a point where she asked a question, the witness answered, and the state was just like, that's false. She was testifying in her questioning, which I think goes
But my favorite
too far.
minute of the trial, I know you've got to seriously know you got to remember. My favorite moment of the trial right here is in this one picture of like I said, the crazy weird lawyer to his right. She's been talking and giggling with the defendant the entire trial, weirdly. And then she wanted to say something, and the jury is sitting straight across the courtroom from them. So she wanted to whisper something. So she held up a notebook in front of their face so that the jury couldn't see their lips move. Evil plans and stuff. Muhahaha, it says.
That's not a good book to be reading. And at least you wonder if juries pick up on that. I think that they're a lot more observant than you think. I think I got to go.
All right.
Thank you, guys.
Love
nice
seeing you, Steve. I'll be emailing you back.
Chandler, thank you very much. I want your wisdom and advice. And she's editing a short story that I've worked on and looking at it, and you're gonna give me your honest opinion. I value your honesty. You know that.
Oh, it's ready. Yeah, I saw you emailed me at 4:30, so I'm ready to email you back after we're done here.
All right, yeah, I need your wisdom, but it's a little short story. It's kind of fun.
I loved it.
Maybe I'll throw it up on my website for something. But all right, God bless you guys.
Thanks.
Bye, Steve.
Thank
See
you,
soon.
Steve. That's Steve. Now, hang on. I have a question here. Flux sent me a mugshot for the lawyer that's sitting directly to the right of the defendant.
Excuse me, at a mugshot?
Exactly, but I can't access it because the Florida, all of the Florida court stuff is blocked from Korean IPs, from foreign IPs. So I don't know what it was for. I'm curious as to what it was for. What was she arrested for? She's apparently 5'11", says Flux.
I'm not sure. Flux sent it to me. I'm curious. I'd love to see it.
Yeah, I can't access it from here, so I don't know. I'm just curious what she did.
If she sends it to me, I can share it on my screen.
It's to be our left and his right. Yeah. So right. I don't have time to turn on the VPN and log in. Just we're gonna move here. All I need to know is what for. It's just she just looks exactly like she does in court. But I was just curious what she was arrested for.
I'm curious too. I'd love to see that.
Well, let us know when you find out. So in the meantime, we have brought up the. All right. Well, we've got to make a decision here. I know we've got a bunch of people watching. We've 943 people watching right now. The court is in recess. Flux says she sent it to you. Battery.
Yeah, I've got it. I can share it right now.
Battery and resisting arrest. Oh, great.
Do you want to see?
I've seen the mugshot because I see the link. I just can't click on the link to see what it was for. So, meh. But we can show the peeps.
All right, let's do it. If you're ready.
I'm ready. I'm waiting for you. Hurry up.
Nope. All right, here we have it. Liberty Raven mugshot. She was arrested in Miami-Dade County. This is her mugshot. She looks very pleased with herself.
Date of birth 75, 180 pounds, 5'11". She's a big one.
Battery.
When?
I don't know. It does not appear to have a date.
Huh. All right.
That's her.
Okay, cool. She hit somebody.
Apparently.
Probably playing hockey, or she was in a bar or something, got in a bar fight or something. I don't know what it was. But we do have. All right, we've got to make a decision here. We've got to make a decision. There's currently nearly 1,000 people watching this. 11:10 here, so it's 10 a.m. there. We think they're going to be in recess until, what they say, 1:30?
I didn't catch it.
Do you remember?
Mm-mm.
I think they said 1:30. So that'd be 11:30. That'd be 3 hours. Some Koreans play hockey. I said hit somebody. You were probably thinking of the Warren Zevon song about Rocket Richard. Anyway, hit somebody, they say there. Yeah, so come back at 1:30. That's 3 hours from now. I can just shut this down, and then we can pick it up tomorrow and do a catch up like we've been doing. Or we can kind of shut it down here in the very near future, and I can get a few hours sleep and start again in the morning. Start again at 1:30. I would be inclined. I would be willing to go to sleep for 3 hours, wake up, and start streaming again.
Well, I'll be around.
Right, let's take down the stupid poll here, and put up a good poll. Here we go. What should we do?
Sounds like a plan.
What should we do? Stop now and come back in 3 hours, or go a while longer and catch up tomorrow. All right, community, we'll give you a few minutes to take the poll here. There's 913 of you here right now. So take the poll and let me know what you think we should do. We'll set the poll for 5 minutes. That'll give everybody a chance to vote here. Stop now and come back in 3 hours, or go a while longer and catch up later. But while we're doing that, let's let that go a little bit, and let's bring up the BITO trial that is in issue here. Righty. Corn Pope came through a while ago and got us our minutes. All right. Great. This is what started it all. This is what started this potential mistrial. Right. Embiggen. And let me double check here. Okay, let's see. I've got to go back and dang it, I hate when StreamYard messes with things. You had this great automatic starring system. That was a weird vocal thing there. Have automatic where all of the super chats would automatically get starred. And then I got used to that, and now they don't do it anymore. So now I have to go back to really, really keeping on top of the super chats. And
if only I could star them for you.
Yeah. So Unhung Hero says full Titanic experience, including sinking to your death. The Titanic kills and kills again. Marv White, OJ Tuesday? No OJ Tuesday. We'll either stop and I'll get a full night's sleep, or I'll get 3 hours sleep and keep going, and then get another little bit of sleep later, which seems to be the way things are leaning right now.
Sleep sounds great. I got up at 4:30.
So that catches us up on the super chats. Thank you, everybody. Legal Vices, share the link in private chat with channels you don't share it. Okay, I'm still scrolled way back. All right, there we go. Almost 600 likes. Yay! Thanks, people. Almost 600 likes.
That is awesome.
So all right, let's do this. Let's watch this little bit here. Now I gotta I'll make the banner explaining what's going on so nobody freaks out. Let's go. This is the start. This is where the judge said, "Don't talk about this stuff."
Threshold on that particular issue.
Thank you. And what says the defense?
Your Honor, I think the state undercuts its argument by admitting what she perceives to be the case, which is that concerning the gravamen of what she's trying to introduce, she believes that the witness is feigning a lack of recollection. In other words, she is recanting. So this is not, and what's important to realize is this is not about determining whether we have a witness who is being honest or not. I think this rule.
Okay, see, this is the important thing to note. He's not, she's saying, oh, she's recanting her statement. She's changing her testimony. Whereas he's saying, no, she's just saying she can't remember. That's the important thing to make. She's not changing her testimony. She's saying she doesn't recall. And so therefore you can't bring in these statements to show she's changing her testimony.
Right. That's the argument. She could be dishonest about that. She could remember and pretend not to remember, but that's not really the issue. That is her testimony.
Determining whether we have a witness who is being honest or not. I think this rule contemplates a witness who may be being dishonest by recanting. And the issue is not whether or not the witness is being dishonest, and in the interest of justice, we want to put in what we believe to be a more honest statement. The question is whether or not you're putting up a witness to impeach them. Putting up a witness to introduce a statement previously made from which that witness has receded, or which that witness has recanted, which is what's going on here. And the rule is clear on that. Can't do it. It's hearsay and it should not be permitted. Any issue with respect to whether or not the statement is sworn or not, I think sworn statements typically contemplate an adversary having the ability to test credibility at the time it's made. Furthermore, this witness, when asked by the state, did you give an honest statement to law enforcement back in 2018? She's like, I don't know that I did. She posited the possibility that she could have been lying then, which further undercuts the indicia of reliability. She also said she felt threatened then because she was speaking, given that she was advised that and I think advised in bad faith, that her daughter might be charged as an accessory after the fact when there was no evidence to suggest that. And she said she was acting then under threat and that she's not certain whether she was being honest then. So for the state now to say, hey, she's having a failure of recollection, so we just want to read her prior statement into the record, is a pretext.
And I agree with him. What he's saying there is, when you make the previous statement, if you want to bring a prior statement in, like something they said before, you have to at least show that it was a true statement at that time. And he's saying that she doesn't know if the previous statement was true or not, because one, she doesn't remember the statement, and two, it's possible she could have misspoke or she could have been dishonest at the time she gave the first statement. There's no indication that her earlier statement to the police was the truth. It's just a statement she gave to the police.
Right. She seems to indicate that her statement to the police might have been marred or colored by either intimidation or some other kind of motivation at the time, which is valid. Certainly.
Yeah, and so they're saying you don't have this proper test met to show that this was a truthful statement at the time it was made. And she's not recanting, she's not changing her testimony, she's saying she does not remember it. And now they just want to bring in this previous statement because she can't remember what she said.
Right. So to declare her as a hostile witness does not seem to be appropriate whatsoever for the state. At least in my opinion.
What was that?
I said at least in my opinion, from where I sit as a layman.
Of the law in the state of Florida, as explicitly outlined in the cases we cited and numerous other cases. So that's why we object.
Thank you. So, counsel, I've looked at a couple of cases that came across. First is 880, 7-2nd, 561.
And right there, you witness the squeaky gate that sometimes sounds like a dog, sometimes sounds like a cockatoo, sometimes sounds like a child. That's the actual squeaky gate itself right there, which really wasn't worth buffering for, but we just did. Yeah, as Jim Satala says, never talk to the cops and keep your mouth shut. So here we get to see the squeaky gate in action.
Is 880, 7-2nd, 561.
Little WD-40 was all it would take to clear that up.
On second, 993, 7-2nd, 1108, 4 DCA case, SL versus state. And in the first case, the Pierce case, that was an issue whereby during cross-examination of a state witness, defense counsel had asked whether or not the witness had previously told detectives and that he made a statement and expressed surprise at some piece of evidence, and the state, his response was he didn't recall, don't remember, anything along those lines. And the end result was that the Supreme Court said in order to resolve this claim, I'm reading from the 8th page of the opinion, it said in order to resolve this claim, we must examine the law relating to the admissibility of prior inconsistent statements. Prior inconsistent statements are not hearsay and can be admitted as substantive evidence. And quotes, if the declarant testifies at trial or hearing and is subject to cross-examination concerning the statement, and the statement is inconsistent with the declarant's testimony and was given under oath subject to the penalty of perjury.
So they're saying that the Supreme Court has said that you can bring in these other statements as a prior inconsistent statement if they testify at the trial and if it was given under oath and if it is in fact a prior inconsistent statement.
At a trial, hearing, or other proceeding or in a deposition. Then it goes on and says this court has held that a statement given under oath during police investigation is not a statement given at an other proceeding and consequently is not admissible.
And a statement given to a police, even though is not a court proceeding, and so therefore is not admissible as a prior inconsistent statement.
So for that, second case I have is SL v. State, as I said, 9937 1108, and that's a little more succinct. And at the second page of the opinion, it says, in order to resolve this appeal, we must determine whether the statement made by SL's mother to the deputy were admissible as substantive evidence. The Florida Rules of Evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding.
So again, this second case is saying basically the same thing. There's Steve bringing the heat. If it is a statement and it's given under oath and is subject to cross-examination and it is contradicted or is contrary to previous statements, then it's admissible.
The deposition. It goes on and says, interpreting this provision, the Florida Supreme Court recognized that a statement given during police investigation is not a statement.
And that's the second Supreme Court case that said, no, a statement given during a police investigation is not a statement given in the proceeding such as he's talking about here.
And other proceeding, end quote. Doesn't appear to me that that statement is admissible as substantive evidence, counsel. So what the end result of all of this is, if you ask the witness guys remembering the statement and you want to read it to them, I don't see how a curative instruction telling a jury it's only for impeachment purposes and not as substantive evidence is going to resolve it.
So right there, because the first thing is this statement given to the police. They want to bring in this. She made a statement to the police and they want to bring it in evidence. But they want to tell, the prosecution wants to use this fiction that it's a legal fiction, essentially. I mean, to where this, and you'll hear it a lot, it's being brought in for not to show that he actually committed the crime, but for the purpose of showing that she's being dishonest. She's giving these prior statements that's not true. We're not doing it to show that what she said really happened. We just want to show that she's saying something different. And you can't do that with the police statement.
And the end result was that the Supreme Court said in order to resolve this claim, I'm reading from the 8th page of the opinion, it said in order to resolve this claim, you must examine the law relating to the admissibility of prior inconsistent statements. Prior inconsistent statements are not hearsay. And
sorry, I went back too far. Sorry about that.
Quotes, if the declarant testifies at trial or hearing and is subject to cross-examination concerning the statement, and the statement is inconsistent with the declarant's testimony and was given under oath subject to the penalty.
Sorry, I went back way too far. Sorry.
Or other proceeding or in a deposition. Then it goes on and says this court has held that a statement given under oath during police investigation is not a statement given at an other proceeding and consequently is not admissible as substantive evidence. The second case I have is...
Oh my God, I went back really far. Sorry. That was bad of me. All right. Sorry about that. I didn't realize it went back that far. So we'll skip forward here and put up with a little.
Is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. It goes on and says, interpreting this provision, the Florida Supreme Court recognized that a statement given during police investigation is not a statement given at an other proceeding, end quote. Doesn't appear to me that that statement is admissible as substantive evidence, counsel.
So the statement that she previously gave to the police is not admissible as substantive evidence.
What the end result of all of this is, if you ask the witness eyes remembering the statement and you want to read it to them, I don't see how a curative instruction telling a jury it's only for impeachment purposes and not as substantive evidence is going to resolve it.
So in other words, the judge sees that they want to get in evidence that's not admissible by not saying here is evidence that this occurred. We don't want you to hear this statement and think that's what she actually meant, that this is actually what happened, that this is her telling the truth. We don't want you to see it that way. We just want you, jury, to see that she said something different than she's saying now. And the court can see through that and say, okay, if you say that, if you just say, look, ignore this, this is just to show she said something different, they're still going to hear what that said, and they're still going to keep that in mind and remember it. So he's not going to let the police statement in. That's his first decision.
So my thought would be just to keep it out. So I sustain the objection.
So just so it's clear, it is not a prior inconsistent statement. So the line of case law that you cited would not be applicable. It's a past recollection recorded, which is a very specific subset. So when I refer to Earhart on that specific issue, 9803 sub 5.
Excuse me one second. Could you get my hand? I left it on my desk.
Yeah, Dom, I'm not an idiot, but see what happens when you fast forward it is it buffers longer. It doesn't buffer if you use the mouse in this situation. So I know what I'm doing. Calm down. The easy way is with the arrow keys. See, arrow keys, this is what happens when you use the arrow keys. Because there's a bajillion people watching this right now with courts. And so to speed up rather than buffering every few minutes, we just skip ahead. Yeah. Right, Bobby. That's what we've been using, the arrow keys.
So she's the prosecutor's making an argument that this is not a prior inconsistent statement, but a past recollection recorded, which is a hearsay exception.
Don't know, not relevant. He said keep it out. Don't know the answer to that question. He said it's not coming in. That's all we need to know. Now we're going to be talking about this text statement. Looks like that's exactly what she's going to be talking about right now. One of the things that led to the motion for the mistrial, which has apparently either been denied or withdrawn. Although it wasn't clear. So come on, Judge.
Citations. I provided a copy to defense and a copy for your honor. And the light is located at 116, 7th 3rd, 270, Florida Supreme Court, 2013.
Why is there a million mosquitoes in my house? What the hell? Is there a screen open somewhere? God dang it.
They want to suck your blood.
Okay. All right. Well, here we are watching everybody sit around. But yeah, okay. So, well, there is a tweet from some attorney legal analyst in New York saying that someone in court said that Friday the motion was denied. So, all right. We'll take that for granted. We'll move forward assuming that the motion for a mistrial was denied. And there's some more inappropriate, weird laughter in front of the jury. No, this isn't in front of the jury. Sorry. Do not want to misspeak. Where is she bringing up the damn text thing here? Huh.
He's got some really interesting face tattoos.
Well, now. Okay, this is annoying to me. Because where the hell did that go?
I'm not sure, but I'll be right back. Give me like 3, 4, 5 minutes.
Oh, great. Just when I need you most. Go ahead.
You'll find it. You'll find it.
All right. What is going on here? Yes, Corn Pope, the Instagram. It was somewhere around here. Well, that was Thursday. He could have ruled on Friday, but whatevs. We're just taking it for granted because why not? There is the Instagram tweet that we are desperately searching for here. And I thought it was right here because there was the police statement and then there was the Instagram statement. Here it is. Starts right away.
Or record. Then it goes on in conclusion. In this case, proceed.
All right, we got to back up a little bit here. All right. This is about where they want to bring in the an Instagram message or post that she made about this trial, an Instagram DM that she sent.
All right, I've read the case. Anything else you wish to share with me, Counsel?
Yeah.
How about from the defense? Anything else?
Well, I'm going to go to sleep here in just a minute.
The case that was provided.
Yep.
The polite case, the very first headnote says that the admission of past recollection recorded under exception to the hearsay rule requires the witness to indicate that the statement was made at the time when the events were fresh in her mind, his or her mind.
That's done.
And also attest to the accuracy of the memorandum on record. The opposite of that.
Excuse me. And that's in the bottom as well. That you're reading the head note.
Yes.
I just highlighted the portion at the end. It says, we reject the 5th District's embrace of a totality of the circumstances test and affirm that in Florida, the admission of past recollection recorded under section 98.803 subsection 5 requires that the witness indicate
Now this isn't where it comes in. Whatever.
Were fresh in his or her mind, and also attest to the accuracy of the memorandum or record. Then it goes on in conclusion. In this case, the proper foundation for admission of the witness' statement of past recollection recorded was not established. As we've explained above, the hearsay statement was inadmissible.
The actual message is brought up at 6:02.
Accuracy or correctness.
Absolutely correct.
Counsel, my thought is this.
Okay. Dang, thank you so much for that. Corn Pope, you are the best. You rock. All right, I thought it was before she started testifying, but I guess they took a break. Now, this is where they want to bring in this DM message. We'll do this, and then I'm going to head to sleep for about 3 hours, and then we'll start up again.
So rules don't allow her to do what she's trying to do.
Thank you.
So you're in further support of treating a witness as a hostile witness. This has previously been provided to defense, but this is the Instagram production for Miss Felicia Holmes that I'm showing the court now, that she has previously identified as her specific Instagram and that it is saying the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies. They didn't want us talking with prosecutors, but now they have all disappeared. I quit my job based on what Track and his wife or company said. Now look, we can't go home. We're spending all my money I worked for and they taking trips and enjoying life. If you think I was a beast before, wait until this trial. I'm not holding anything back. I'm doing what I should have done in the beginning. They can call me Miss Snitch Bitch. So Judge, it's very clear from this record that my intention and what the witness has represented to me in all shapes and forms that she was going to be honest and truthful. So to say that it's improper for calling her just for the purposes of impeachment is incorrect. So to continue on in that same Instagram production, and this is in June of 2022, Felicia Holmes is saying, they made me quit. Told me that they would take care of us until trial was over. But guess what? Lies as usual. I was making $9,000 weekly. I didn't need shit from them, but everyone begging and pleading. Now they all ghost. I got something for Track though. He lied to me and my child for the last time. Again, saying you're going to air him out to the prosecutor. So Judge, in terms of, so that's in defense of the representation of counsel that is just being called for impeachment. It's also clear that this witness has received multiple benefits from the defendant based on her own statements there, that she has endorsed that that was her Instagram on that.
So, counsel, there's a couple things going on here. Number one.
Okay, so she's saying she said this in her Instagram. So, she's admitted that was her Instagram, so therefore it must be true. So it should be let in.
Is you indicated that it was the testimony was going to be admitted because it was in essence, I forget the statute number.
9803 sub 5, it's a past recollection reported.
Past recollection reported, and you gave me the polite case.
Yes.
And that
You missed the past recollection recorded explanation, Chandler, because you just had to leave.
Oh, I was listening.
Okay, so you heard the past recollection recorded requirements.
Yes.
That it'd be closer to the time and it'd be true.
That indicates that you have to have a proper foundation, but it has to be not only there's a proper foundation, but it has to, the hearsay statement was inadmissible in that case because the witness did not vouch for its accuracy or correctness, which is what we have here.
So you in order for it to come in, the witness has to vouch that it was an accurate and true statement when it was made. And she's saying, I don't remember if it was true or not. I don't remember anything about it.
The witness isn't vouching for the correctness or accuracy of the statement. So it doesn't meet that criteria.
So the witness is not vouching for the truthfulness of that statement in the Instagram message. So therefore you cannot bring it in, is what he said.
Yeah. Close.
Now, if she said, oh yeah, I remember, and that was a true statement I made in my Instagram, then they could probably bring it in. But she didn't say that.
On the other issue about impeachment, this is not what she said. She's, she said, gave me a different answer. What I tried to read before was something from a couple of cases. And again, the synopsis at the end of it, I'm just reading again from the SL, a child case, the state 993 Southern 2nd, 1108. It just says the Florida rules of evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at the trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. Goes on and says, interpreting this position, the Supreme Court of Florida recognized that a statement given during a police investigation is not a statement given at and other proceeding. So then if you agree, I don't know where we're going with this, counsel, respectfully. It seems to me under either scenario, that statement doesn't connect. Now, I do.
Now, listen to how clearly the judge said that. Respectfully, counsel, I don't know where you're going with this. That's judge speak for, I don't know what the hell you're talking about. I don't know what you're trying to do here, but it ain't coming in. I respectfully counsel, I don't know where you're going with this, means stop talking about it. You're totally wrong and I have no idea what you're talking about. And you're just dead not going to have this happen. So he said that under either of these tests you're bringing up, inconsistent statement or prior statement recorded, it's not coming in.
You have a message from Mr. Bears, B-E-R-E-S. She says he is Ms. Holmes' attorney. He would like to speak with me. I don't know what he wants to talk with me about.
So that is the judge's statement saying this will not come in. The judge has just decided this statement she read, this DM from Instagram she read, does not come in. And then let's kind of go back here a little bit. So about 7:03 is when it happened. So let's go back to about 6:55, maybe 6:58. Let's see. Has he already made the statement? I guess not.
The faces he makes are just...
we fast forwarded too much. Now we got to buffer a little bit here.
They should have coached him a little bit on, try not to like visibly react during the trial.
He apparently has been diagnosed with ADHD and I believe autism of some sort. But still, someone just needs to be there to go, bring it in.
Yeah, poke him a little.
Long sidebar.
For research.
Yeah, I mean, with the sidebars, I could see how it might be hard for him to sit still, having ADHD and all.
Lack of foundation calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. The objection noted. That's what I previously ruled on sidebar. Proceed to your approach.
Showing me your messages from Instagram.
And she just, this is like, what, 2 hours later, she just walks up after she said, do you lie to the police? Do you lie? She wants to make it sound like, okay, she said this was an honest statement, but she didn't say that about this Instagram. She just walks up and says, is this your Instagram thing? Remember, the judge just said under either one of these theories you have for bringing this in, you are not allowed to bring this in. And so here she goes, here's an Instagram from...
Your approach.
It's really dirty.
Showing me your messages from Instagram from February 5th, 2021.
Who was that Instagram? Is that the one with this when we stand support?
That's a random buffering thing. I didn't even do anything. Be kind to me.
Ma'am,
I don't remember that Instagram.
Look at it.
I already looked at it. You already showed it to me.
So is the...
I don't remember that.
See, if she says, yes, that was a true statement. Yes, I sent that text. Then it could possibly come in. But she said, no, I don't remember saying this. Which is not a prior inconsistent statement. She's saying, I don't remember it. It's not like she's saying something different. And she's not acknowledging that was a true statement.
And like the way that she's interacting with the witness, she's very aggressive with her. She's like, look at it. Just the way she's...
Well, she has been declared a hostile witness at this point. So she gets to cross-examine her, basically.
Can we declare a hostile prosecutor in these cases?
Yeah.
So it's like 3 times already.
So you don't recall making a statement?
Excuse me, one at a time, please. Let her finish her answer before you ask the next question.
So you don't recall making that statement?
No, I don't.
So you don't recall saying...
Objection.
Sustained.
So...
See, there he said it. She said, so you don't recall, and she was going to read it, and then he objected, and it was sustained. The next time she tries it, the court just lets it go. You know, the defense just lets it go and doesn't object until it's after, and then he makes the motion for a mistrial.
Ms. Holmes, you said that
He lets it go
your
this
daughter
time.
didn't tell you.
Objection, asked and answered.
Sustained.
So did you ever make a statement that's different than that?
Objection, asked and answered.
Sustained.
Into the statements that with regards to October 26th of 2008.
All right. What without a buffer in here, people?
Is it your testimony to the jury that you...
Oh, come on. Well, one thing I'm going to do when I go to sleep is I'm going to have to delete my
remember coming to Fort Lauderdale?
Objection, asked and answered.
Sustained. Listen, I just want one of you making objections. Whoever's going to handle it.
Yes, sir.
All right?
I apologize.
So you can see she's trying desperately to get this in. She's trying so many ways of asking this question. Do you don't recall saying this? You don't remember someone else mentioning this? You don't recall saying this? You don't recall going over? She's trying so many different ways of getting this statement in.
Ms. Holmes, is it your testimony you don't remember why you came down?
I told you why I came down.
Okay, why is that?
Objection, asked and answered.
Sustained.
Ms. Holmes, have you ever let me rephrase.
Right, silent tips. Right. That's exactly the situation.
Ms. Holmes,
Yeah, this isn't a Korean internet problem. This is just time to empty the cache and reboot. So as soon as she has this question, we'll wrap it up, and then I'll get a couple hours sleep, and we'll come back.
did your daughter ever threaten to cooperate with law enforcement?
Objection.
Sustained.
Ms. Holmes, did you threaten to cooperate with law enforcement?
Objection, asked and answered.
Different question.
Why don't you come sidebar? I want to see the question, please.
Great. Now they're going to the sidebar, so we'll skip through the sidebar. Yay! And then when I go to sleep, then we shall just fast forward through all of this. Just kind of getting a little buffer build up here. She's a big woman. She's like 5'11". All right. Now, during that sidebar, during that sidebar, the judge is like, come on, prosecutor, knock this crap off. And this is where it goes.
Ms. Holmes, did you ever make any statements about what happened on October 26th of 2018?
Objection, asked and answered.
I don't know what statement you're talking about. Rephrase your question to a specific.
Ms. Holmes, did you ever make any statements specific to what was happening in the car on October 26th of 2018 prior to the homicide?
Objection.
Thank you. I still come on sidebar, please.
And another sidebar. Ooh, and breaking news, Hunter Biden seems to have taken a plea deal on tax and gun charges and has avoided prison. Interesting.
Ooh. Spicy. That's intriguing. I'll have to read more about that later.
All right, looks like
buffering.
We're gonna limp into the end here, and then we'll just have to. Like I said, we'll just reboot everything and clear my cache flow. Honestly,
Holmes, I want to ask: were you present?
Yep, this one's on me, folks. Time to clear ye oldie cache.
Well, the suspense is compelling. Try to frame it in a Pollyanna-ish sort of way.
Well, is it this compelling is the question. We're like right here on the cusp. All righty. Well, 7:05:53. We'll do it the manual way. Yeah, this is we just may be perma buffered. Well, I have a remedy. I hope it works. Probably won't, but I'll give it a crack. Pause that bad boy.
When your daughter spoke with law enforcement?
She was 17, had been present.
Do you recall about when that happened?
If she was 17, that happened in 2018.
Okay. Without getting into what she said on that. Do you remember where that statement was taken?
No.
When you came down to Fort Lauderdale, was your daughter concerned for Mr. Dennis?
Objection. Cause for a conclusion on the part of this witness.
Based on your daughter.
And I love how he doesn't even sit down. He just knows. Yeah. He just knows there's going to be an objection, so he's not even sitting down anymore.
When you arrived
he's ready.
in Fort Lauderdale and saw Mr. Dennis, did you ask him what happened?
Objection. Asked and answered.
I'm sorry, repeat the question.
When you arrived in Fort Lauderdale, did you ask Mr. Dennis what had happened?
No, I did not.
Nothing further.
I have one question.
Yes, sir.
You came here and one of your first, let me get it.
Objection, Your Honor, improper.
I haven't asked you.
Counsel, you direct your comments.
I like that. I have one question. Improper. I haven't even asked the question yet.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, I feel threatened.
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
What the rules?
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Anything else in this witness?
Yes, sir.
Huge.
Ms. Holmes, you said you feel threatened by me.
Of course.
Okay. Did you fail to appear for numerous court appearances?
No, I never served me, lied.
Okay.
Lied to the court.
And with regards to, did you work in Redding, California?
Yes, I did.
Okay.
Immaterial.
Overruled.
And so that was a location you were at?
That's why I was traveling or something. Yes.
Okay. And in terms of the prosecution, you have been served on various occasions to testify.
You served me a subpoena on November to be the next weekend. I was in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in
Never.
February of 2019.
You never served me. I know you served me to a location. I didn't live at anymore.
Do you recall coming to the courthouse in February of 2019?
Objection beyond the scope.
Excuse me.
Anything about the courthouse tonight.
Excuse me. No sidebars.
And another sidebar. And someone's asking, who is the bald guy? Which bald guy? The bald judge? The bald court clerk? The bald
defense attorney,
white defense lawyer? Or the bald black defense attorney? Which bald guy are you talking about?
Attorney. Yeah. He's taking up most of the airtime. Other than
You even went so far as to hire an attorney
Yes,
to
I
try
did.
not to show up.
I sure did.
And has the state offered you any money?
The state basically has me on a monitor. I have to go to my job with this. It's embarrassing. People think I'm a criminal. The state has ruined my life.
And in
The
terms
state has
of
ruined my
your
life.
feelings and ill will towards the state and myself,
I just feel like you lock up innocent people.
and does that influence your testimony today?
It's not influencing my testimony.
Have
No,
you-
I'm telling you,
have you- that's not-
I
Can you
know.
understand?
Excuse me, hold on. Only one of you can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, Your Honor. So my question was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued, you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay, you hired an attorney to go and represent you at the Fourth District Court of Appeals?
He had to hire an attorney because he tried to get him this far.
And no, that's a false statement.
Objection.
Excuse me, counsel, you're not testifying. all right?
That was the time when she testified, when the witness gave an answer and the lawyer said, that's a false statement. Lawyers can't do that. That's for the jury to decide whether it's a false statement or not.
And she knows better. I mean, she's really, crossing lines. I mean, it's very clear that she's aware of the rules of the court, and she's just flagrantly violating them, which is disgusting and egregious and insidious.
And that's why the defense lawyer is just having a stroke here about that.
Yeah, I'd be
Listen to her,
furious if I were defense, definitely.
Listen to the prosecutor. She says, that's a false statement.
Represent you at the Fourth District Court of Appeals?
He had to hire an attorney because he tried to get him this far.
And no, that's a false statement.
Objection.
Excuse me, counsel, you're not testifying. all
I
right?
agree on
You
that.
Excuse me, you ask a question, all right? That's it, you ask the question.
And so, Ms. Holmes, with regards to that, you hired an attorney?
Yes.
And you then tried to get any sort of court order requiring you to be here in court thrown out?
No, what I did was I hired an attorney because you were saying you served me the subpoena that you never served.
And that was found to be valid?
You never served me a subpoena you never served me.
Oh.
I've never seen a subpoena from you from those addresses that you said you served. Those
So-
are not my addresses.
Your testimony is that you have never been served to appear in court?
Objection,
I've
asked
served-
and
I've
answered.
never-
Sustain. Excuse me, sustain.
And so, with regards to your feeling threatened on them, have I ever, any sort of physical violence against you? No. Do you have any written threats from me?
It's intimidating. You've intimidated me this whole time. As of now.
And in terms of your
Dude.
participation in this case, yes, you understand that you were served a subpoena to appear here today?
You served a subpoena after you arrested me. You
And
served a
you,
subpoena at the jail when I was in Brown County.
and you understand you were here pursuant to that court order?
I'm here.
And that requires, under the law, to comply with court orders and that compel attendance of witnesses.
I've been complying.
Nothing further.
Anything further?
Wow.
No,
She
sir.
intimidated me
Thank
this
you.
whole time.
Is
That's a
witness
statement.
excused?
Yes, Your Honor.
Thank you, ma'am, you may step down, you're excused.
How did we miss the mistrial part?
I'm really not sure.
How did we miss that?
I don't recall precisely when it came in.
Huh.
When did it come in? When did it come in? I just watched it. I don't remember.
But we played the whole thing. That's weird.
Ugh, next time I'll do timestamps.
Yeah. Huh. Anyway, at some point, wow, how did we miss that? That's weird. That's why timestamps are important. I need to hire someone to do timestamps, don't I?
Well, I'd be happy to do it next time. As long as I have a little advance notice.
Yeah, I didn't know we were replaying this either. Huh, that's weird. The mistrial is at the end of this, but this is the end because she's off the stand now.
Sidebar here, please.
They have the arguments about the mistrial, but the moment where what happened, to make a long story short, at some point, the prosecutor just read that tweet, that Instagram message that she was specifically told not to do. She read it, and the defense lawyer stood up and said, objection, move for mistrial. keep it going. People say it comes later. Okay. See, we're coming back on Tuesday. Now, see, you guys are talking about the motion itself.
By the way, I love the comment from JKD Buck, which said that if sidebars were sidecars in this trial, Steve Gosney would be way drunk.
Court was advising you. I don't know if it was. I don't think there's any evidence that she had something that might have been marked as an exhibit.
It was not marked on it. It was just a copy of the transcript.
Yeah, but see, this is where they're talking about the mistrial. It's straight out. It can't be straight after this because she's off the stand. I think we have what we have here may be a failure to communicate. So 717 is the motion for a mistrial. Oh, she's back. Is she what? 717?
I'll try it.
Yeah. I think we have a failure to communicate here.
It happens.
They declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise.
Yeah, see, this is where they're arguing the mistrial. Yeah, see, no, we don't want the discussion starting about the mistrial. We want the motion in the trial where she read the statement to the witness and the defense lawyer objected and called for a mistrial. So yeah, but anyway, it's beside the point. It happened, and then they argued about it. I know it was during the direct. Cross-examination was 2 questions. I know it happened during direct, but somehow we skipped over it. But anyway, that's beside the point. It's late here. It's 12:04, 2.5 hours until the court comes back. What we do have is, again, he said he would rule Tuesday on the mistrial motion, take it under advisement and rule on Tuesday. But people at Law and Cuck are saying that they already have ruled on it. So let me cue this little bit of business up here from our folks at Law and Crime. Let's see. We're bringing this up. Why are we having difficulties? I know we're having difficulties because people are dumb, and that would be me. Share our screen. This was tweeted to me by Voodoo Berries.
Order denying the motion for a mistrial this past Friday. Defense attorney Stuart Adelson told our very own Terry Austin that the attorneys were given the written order denying this mistrial. So it was denied. We were curious which way the judge was going to go. We were wondering whether or not the judge would actually vote in favor of the mistrial. That is not happening. What's your thoughts on that?
It's a really difficult burden for the defense. I mean, they can, a lot of this is preserving objections for appeal. So you understand why they make the objections, but it really weighs heavily in favor of the prosecution. The judge essentially has to find that the trial, for whatever reason, this is, based upon questions asked by the prosecution, perhaps testifying during the questions, whatever kind of inadmissible evidence may have come before the jury. Does the judge feel that bell simply can't be unrung?
And I think it can't be unrung, but what do I know? So there we have it. There was a written order on Friday denying the motion. I think we can lay that issue to rest. Thank you, Voodoo Berries, for finding that and sending it to me. So what's going to happen now? It's 12:07 a.m. here. Court's going to start at 2:30 a.m. So I'm going to shut this down now. I'm going to get maybe a 2-hour and 15-minute power nap. And we'll start again in the afternoon and see how long I can keep going. The court usually finishes pretty early, so probably like 6. I might be able to get another hour or 2 in after trial. But so that's what we'll do. We'll shut it down now because nothing's happening. What Budaberry says she sent another. I don't need another update, I don't think, because I'm going to sleep unless it's the court saying we're back in court. No, you wait, what? Budaberries, you said you sent another update, but there is no other update. All right. Don't know what that was all about, but cool. Legal advice is all really good stuff for a possible appeal if he's found guilty. I think so. All right, everybody. Thank you. Let's just shut this down now before I don't get any time to take a nap. So,
everybody's telling you to sleep. Go to sleep.
I'm going to go to sleep right now for 2 hours and about 15 minutes. Chandler, are you going to be back then, or you got to go about your day?
Oh, I'll be back. I'm going to work for a couple hours, and I'll be hopefully a little more awake by then, so I can be a little chattier, contribute a little more verbally.
Well, if I'm not awake, I'm still asleep. So if it doesn't start at 1:30 Eastern time, I didn't wake up for whatever reason. But I think I'll be good. All right, everybody. Thank you for being here. What do we have? 635 of you are still here. We will pick it up again in the afternoon session. I'll make a little thumbnail, set the link, and everybody will be here. See you in a couple hours, guys. Thank you, mods, for putting up with this. Thank you, chat, for putting up with this. Please hit that like and subscribe on your way out. Make sure you go to Remy_legal and subscribe to her as well. She'll be back in a couple of hours with me and checking on the current status of the subscriptions. We need 10 more subscribers to get to 36,900. So on your way out, 10 of you, 10 of the 614 of you that are here now, just hit that subscribe button. So that when I wake up 2 hours and 20 minutes from now, I'll go, oh my God, I hit 36,900 subscribers. And give Chandler a couple hundred while she's waiting too. All right, everybody, chat. You guys are awesome. Thank you so much for the super chats. We will keep this going in 2 hours and a little bit. Take care, everybody. Thanks, Chandler. Thanks, chat. Thanks, mods. Thank everybody. Bye now. Oops, that's not the end one I want to hit. I want to hit this end broadcast button right there. Bye, everybody. Lawrex out.